Welcome to the futurist public intellectual. The Supreme Court published some blockbuster opinions recently, so I want to continue to talk about them. I think it's particularly important because they address various political issues that are very topical. Today's episode is about Biden v. Nebraska. The Department of Education announced in August 2022 that it was going to forgive up to $10,000 for borrowers who made less than $125,000 in 2020 or 2021 and up to $20,000 for Pell Grant recipients. The student loan forgiveness program would have encompassed 98.5% of all borrowers and $430 billion. Considering that is almost 2% of the entire multi-trillion-dollar U.S. economy, it is quite staggering. The majority concluded that the Higher Education Relief Opportunities for Students Act of 2003, aka the HEROES Act, does not authorize the Secretary of Education to enact a loan forgiveness program of such magnitude. The HEROES Act allows the Secretary to, quote, waive or modify any statutory or regulatory provision applicable to the student financial assistance programs as the Secretary deems necessary in connection with a war or other military operation or national emergency, end quote. Since the COVID-19 pandemic was declared a national emergency by the President, the Secretary was legally authorized to execute such waivers or modifications. The majority simply disagreed that the Secretary's authority extends to a full-scale cancellation of the student loans. It doesn't make sense for the executive branch to be arguing over the meaning of the words waive or modify. If this student loan forgiveness program had the blessing of Congress, then the Supreme Court's nullification of it shouldn't matter much. Since the majority accurately points out that Congress has control of the purse, Congress can just pass a law reinstating the Department of Education's loan forgiveness program. It's precisely because the loan forgiveness was controversial that there's credence to the court's skepticism of the Secretary's alleged authority to cancel federal debt, money that Congress would have to accept as a loss. Justice Kagan's dissent, however, was significantly better than the dissents in Students for Fair Admissions v. Harvard. Her most persuasive argument was that Missouri lacks standing to bring this lawsuit because its state-owned corporation, Mohela, didn't bring this lawsuit, despite having the legally cognizable power to do so. I thought that this was an excellent point. If Mohela itself couldn't be bothered to sue the executive branch, then why is this case proceeding under the assumption that Mohela has been injured by the Secretary's actions? Justice Kagan's other fair point, though not as persuasive, is her assertion that the language of the HEROES Act indicates that Congress gave a broad delegation of powers to the Secretary of Education during national emergencies. Well, that's true only if we look at the language of the paragraph involving the phrase waive or modify. However, if we look at two subsequent subsections in the law, one definitely gets the sense that Congress's delegation was more limited. Subsection 2b states that, quote, administrative requirements placed on affected individuals who are recipients of student financial assistance are minimized to the extent possible without impairing the integrity of the student financial assistance programs to ease the burden on such students and avoid inadvertent technical violations or defaults, end quote. Subsection 2e states that institutions of higher education and eligible lenders, quote, may be granted temporary relief from requirements that are rendered infeasible or unreasonable by a national emergency, including due diligence requirements and reporting deadlines, end quote. In context, the waivers and modifications that Congress seems to expect the Secretary to make seem to be ones that are much more circumscribed than wholesale cancellation of the loans themselves. Consequently, the majority's analysis makes sense. I think the biggest thing that no one has explicitly addressed, even though it was briefly mentioned in the majority opinion, is the fact that President Biden declared that the pandemic was over a few weeks after the announcement of the student loan forgiveness program. While the loan forgiveness technically occurred during the emergency, and one could argue that an emergency's impact doesn't happen only during the period of its existence, it's reasonable to be skeptical of canceling loans that, in many cases, took years to accumulate and would have potentially taken decades to repay. Thank you for listening to the Futurist Public Intellectual.